Morning, everyone. I call the House Judiciary Committee to order. Mr. Clerk, please call the roll.
Representative Banta,
Present.
Representative Baumann,
Present.
Representative Blanton,
Present.
Representative Burke, Representative Dietz,
Here.
Representative Flannery,
Here.
Representative Griffey, Representative Kulkarni, Representative Lewis,
Here.
Representative Maddox,
Here.
Representative Marzian, Representative Moser, Representative Nemus,
Here.
Representative Petrie, Representative Roberts,
Here.
Representative Stevenson, Representative Whitaker, Representative Williams, Representative Wilson, Vice Chair Decker,
Present.
Chair Elliott.
I'm here, so we do have a quorum and we're duly constituted to conduct business. This is our third meeting of the 2026 session, and we have three items for consideration today, three different bills. And the first one that we will hear is House Bill 50, an act relating to the removal of persons unlawfully occupying real property, and the sponsor of that is Representative Emily Callaway. And I would also notify the members that we do have a letter in the folder that was submitted by the Apartment Association of Kentucky. So if you'll introduce yourself and then proceed.
Sure. Thank you, Chairman. I'm Emily Callaway, District 37. So last session, we passed Common Sense House Bill 10 in response to an uptick in criminal trespassing by squatters. So I'm happy to report we've heard positive feedback about the implementation, including KSP, who's been cooperative about the documentation, and our sheriff's departments have really stepped up and collaborated with our local law enforcement officers and departments. So I'm really grateful for all of those who've stepped up and done a really good job of implementing House Bill 10. So as I've continued to follow up, my local LMPD and Jefferson County attorney had questions, and so I drafted this language in response. That's all this is. We want to make sure that they're.
So the motion and a second. Does any member have questions or comments that they'd like to make about House Bill 50? Seeing none, Mr. Clerk, please call the roll.
Representative Banta,
Yes.
Representative Baumann,
Yes.
Representative Blanton, Representative Burke, Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Flannery,
Yes.
Representative Griffey,
Yes.
Representative Kulkarni, Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Marzian, Representative Moser,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Roberts,
Yes.
Representative Stevenson, Representative Whitaker, Representative Williams, Representative Wilson,
Yes.
Chair Elliott.
Aye. So with 16 yes votes and no votes and no pass votes, House Bill 50 is passed and will be reported with favorable expression that the same should pass. Congratulations. The next item on the agenda is House Bill 249, an act relating to involuntary commitment. Representative Whitaker, who is a member of the committee. And if you would introduce yourselves and proceed.
Thank you, Chairman and members of the committee. I'm Mitch Whitaker, representative of the 94th District. I've got Jackie Steele with me here. So our current involuntary commitment law allows judges to involuntarily commit defendants to psychiatric facilities if they're mentally incompetent to stand trial. But it only applies to defendants charged with Class A felonies, certain heinous Class B felonies, rape, and sodomy. It doesn't cover other sexual crimes, though, including inappropriate touching of a minor. So such offenders have been and will be set free without any form of treatment or supervision if we don't act. House Bill 249 will allow judges to keep our community safe by applying our current involuntary commitment law to sexual abuse in the first degree. Now I'll let the Honorable Jackie Steele speak briefly about the bill.
I am Jackie Steele, the Commonwealth Attorney in Laurel and Knox County, Kentucky, the 27th Judicial Circuit. I was asked to come up here and speak in regards to the bill. The Commonwealth Attorney Association has talked about the bill. We do favor the bill the way it's written. There is an issue out there when you're talking about sex offenses under KRS Chapter 510. These are repeat offenders. These are not, even though they're not a B or A felony as required under 202C at this point in time, a violent offender, they are people that are going to go back, and if you look at the numbers through Department of Corrections, there is a high likelihood that they're going to reoffend. There's going to be more victims because of their actions, and those are the people that really need treatment as much as anybody, so that we can protect our individuals in the street, mainly younger children, as the bill's written under sex abuse. I'd be happy to answer any questions.
Second.
So there's a motion and a second to adopt the bill. Does any member have discussion that they would?
Real briefly,
Yes.
Chairman, I didn't mention his title. He is the, which district do you represent?
The 27th, Laurel and Knox County.
Yeah, he is the Commonwealth Attorney for Laurel and Knox County and an outstanding prosecutor here in the state of Kentucky that's very well respected amongst the bar.
Thank you for being with us, Mr. Steele. I know we've been together in other capacities here in the General Assembly, so thank you for being here. And this is a Class D felony, sex abuse first. Is that right?
It is, unless it's a child under 12, then it is a Class C felony.
Yes. Okay.
Yes, sir.
So, Mr. Clerk, would you please call the roll?
Representative Banta,
Yes.
Representative Baumann,
Yes.
Representative Blanton, Representative Burke,
May I explain my vote?
Yes, you can.
I'm going to pass because I'd like to have a continued conversation, but I look forward to supporting it on the floor. Thank you.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Flannery,
Yes.
Representative Griffey,
Yes.
Representative Kulkarni, Representative Lewis,
Yes.
Representative Maddox, Representative Marzian, Representative Moser,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Roberts,
Yes.
Representative Stevenson, Representative Whitaker,
Yes.
Representative Williams, Representative Wilson,
Yes.
Chair Elliott.
Aye.
I appreciate you.
So with 15 yes votes, no votes, and 1 pass vote, House Bill 249 is passed and will be reported with favorable expression. So congratulations, and thank you for being here today.
Thank you, Representative.
Appreciate it. So the final bill on our agenda is House Bill 305, Representative Massaroni, an act relating to grand jury service. And if
Motion on the committee sub. Second.
And there's a motion and there's a second for the sub. Is all those in favor, please say aye.
Aye.
Those opposed, no. And the motion is adopted. Representative Marzian, you're seeking
Thank you,
recognition.
Mr. Chair. I just wanted to ask what the difference of the sub and the original bill.
Yes, ma'am. The sub, it extends the statute of limitations for 10 years for the secret recordings, and and it lowers for the hearsay crimes to 5 years.
Yeah, a recording would be 10 years and a communication that isn't recorded would be 5 years. And there's also some language related to the discovery issue of when the Commonwealth should have known that it occurred, should or should have known. So those are the changes. So that's correct. And you may introduce yourselves and proceed.
Thank you, Chair. Thank you for committee. My name is Candy Massaroni. I'm the state rep for District 50 in Nelson County. And today with me I have Sherry Ballard, who is a constituent of mine. This bill, it's a fairly simple bill. It's just to protect the integrity of the grand jury and, like I said, to extend the statute of limitations for anybody secretly recording grand jury testimony. And if you don't mind, Ms. Ballard would like to make a few comments.
Yes, please, and thank you for being here
You're
with us this morning.
You're very welcome. First of all, I would just like to say thank you for giving me the privilege of getting to talk in front of you all. For any of you that don't know me, my name is Sherry Ballard. I'm the mother of Crystal Rogers. Crystal went missing on July the 4th of 2015. Brooks Houck was her living boyfriend at the time, and he was a person responsible for my daughter's death. They shared one child together. Crystal left behind 5 children. Her father, Tommy Ballard, was murdered on November the 19th of 2016 because he would not give up looking for our daughter. Crystal was 35 years old when she went missing. She was supposed to be having a nice night out with her boyfriend, and she never returned. We never saw her again after that night. Brooks Houck was the last person to see her alive. During the investigation of my daughter's disappearance, the FBI discovered some recordings found during a search at the Houck farm. This was like years after my daughter went missing. This was the last place, the farm was the last place my daughter was supposed to be seen. Brooks Houck, his mother Rosemary Houck, his brother Nick, his sister Rhonda, and his mother's live-in boyfriend Larry Mock all secretly recorded their grand jury hearing. Unfortunately, when these recordings were found, the statute of limitations were well past the limited time that the law allowed. I cannot express the devastation my family felt knowing that this whole family had recorded their testimonies and there was nothing we could do about it. I just feel that the 1-year statute of limitation is not compliable with something as important as a grand jury hearing. And I can only pray that each of you can only imagine what my family has been through. And now I'm asking each of you to support the House Bill 305 and let you know how very important this bill is to me. I know this will not help my family, but hopefully it will help another family and they will not feel the pain that my family has had to go through. Brooks Houck and 2 of his accomplices are behind bars today and they are in prison. It took 10 long, grueling years to put them there. So please consider this bill, and I ask that you will vote for this. Thank you for your time.
Motion on the bill.
So there's a motion on the bill as amended by the committee substitute. Is there a second? There is a second. Thank you for your comments.
You're very welcome. Thank
And
you.
I can't imagine what you've been through. As we talked earlier, I've watched you handle this situation with great poise and
Thank
on
you.
Dateline and on national TV. But you're making a difference. You've made a difference, and your persistence has worked out for your daughter because there's been a conviction.
Thank
And
you.
I watched the trial very closely. So you have my prayers and my sympathy,
Thank you.
and I know I speak for the entire committee
It's been hard.
when I say that. And I know it's been very hard, and it's not easy to do this
No.
either.
Thank you.
So we're grateful for you being here this morning. Mr. Steele, do you have any comments?
Just real quick, again, Jackie Steele, the Commonwealth Attorney, 27th Judicial Circuit. Again, our heart goes out to the family in that situation. And that is just one area of which this is an issue. You have individuals that may be recording the grand jury in regards to drug trafficking that are using that, taking it out in the community. You also have, as unfortunate as it is, you have a black market for child abuse material. When an officer is speaking in regards to the horrors of child abuse, there's actually a black market out there for people that will buy that. So we're all for the bill. The Commonwealth Attorney Association is absolutely for this. There's protections in the judicial system for that material so it doesn't get out. But if somebody's recording it unknowingly, it gets out. We do ask for a tweak, an amendment to this. The way the bill's drafted right now, a public servant as defined would be the Commonwealth Attorney's Office. the way that the bill's drafted right now, it would be a Class D felony for us to do our job. So the way the grand jury works now is we'll meet the grand jury. The grand jury may say, Mr. Steele, we would like a subpoena for medical records or cell phone records. At that point in time, I have to go out, prepare a subpoena, and then issue that subpoena. I'm giving information that I have gathered from a grand jury proceeding and putting it out. Also, it may be in regards to, hey, we would like the officer to go interview ABC. I call the officer up because the grand jury does not have officer's phone number. A grand jury is an investigative body, and the way the rules are, we're there to assist them in their investigation, and many times it is to say, officer, go to this interview, report back to the grand jury. Officer, I'm getting these phone records. We need to sit down and look at them so you can report back to the grand jury what they are part of. So that's the only issue with the bill. We are for the bill, other than just allowing us to do our job without committing a D felony.
And unfortunately, I have a different interpretation of that, and I understand your position. I think the first line of this says, except as allowed under the Kentucky Rules of Criminal Procedure, which I think covers what you're talking about, but there's always room for disagreement. We're in America, so that's what we do in America is disagree sometimes. So.
Chairman,
but I appreciate your comments.
If I could say the rules of evidence only speak to disclosure of the recording after an indictment. So that's the only thing the rules of evidence speak to. And again, we can disagree, but being on the side of somebody who may be charged with Class D felony, I want to err on the side of caution, and I respect your opinion.
I understand. I understand.
I do.
Any other member with questions or comments? Representative Demas.
Thank you, Mr. Chairman. First of all, I want to say that, we all align ourselves with the comments of the chairman who did speak on behalf of the committee. I want to thank Representative Mastroni for filing this bill and bringing this bill. She's worked on it really hard. Ms. Ballard, your situation has captivated Kentuckians. I know my wife, for one, has prayed for your family. I know a lot of us have as well. So I just have a question for my friend, Mr. Steele, because not everybody on this committee is a lawyer, and many of us who are lawyers are not criminal lawyers. So before I ask my question, I will say I don't think there's any disagreement with making sure that you guys are covered to do an investigation. We can make changes that are necessary. That's not what we're hunting. I just want to be clear.
Sure,
that
I understand that.
Yeah. So my question for you is, why is it important that we not allow people to record in the grand jury proceedings and share it with the people outside in the public? Just highlight for everyone why that's important.
In easiest way to put it, and Representative Neves know this, in a trial we have what's the golden rule: separation of witnesses. That way, witnesses cannot alter their testimony for one side or the other. If Mr. Smith testified that they went and got a pizza first, and that way the next witness, Mr. Jones, comes up and he can say, "Oh yeah, we went and got a pizza," when in fact they didn't get a pizza. He can say, "Oh, he messed that up. I'm gonna make sure I'm gonna go with his story. I'm gonna cover for him." So that's the rule on witnesses, and we don't have that in grand jury because they are supposed to be secretive. So with this rule, it does make it an issue, making it secretive. That way, further testimony cannot be tailored to cover for somebody.
So in some, if it's allowed to be out to the public, it taints an investigation, allows bad actors to continue their misconduct and maybe dodge a legitimate prosecution.
Absolutely.
Okay. Thank you, Mr. Chairman.
And I think also when you think about somebody who's trying to disseminate information from a grand jury proceeding, they're typically trying to obstruct justice. They're trying to obstruct an investigation, to interfere with it, to tell the target of the grand jury what the prosecutor is asking about, specifically with respect to that case. So it's really, I think, at the very base, obstruction of justice, and we have to stop that. This will be known as the Crystal Rogers Act. And so,
Thank you.
yeah. Representative Wilson.
Thank you, Mr. Chair. My question, I believe, has been touched on. I was curious if there would need to be an exemption for the Commonwealth Attorney's Office under this, just to ensure they're exempted. So thank you.
I think we have touched on that, and I have too. So, Vice Chair Decker.
I would have said what my colleagues have said to encourage and thank you. But I also want to thank the bill
Thank you.
sponsor for bringing this to us and for allowing us to take care of this problem. Thank you.
Representative Burke.
Thank you, Mr. Chair. I also want to echo the members who have said thank you to the bill's sponsor and thank you to the prosecutor, but especially thank you, Mrs. Ballard. Your courage,
Thank you.
your tenacity on behalf of your daughter has inspired all of us. And you are doing such a great honor to her memory by helping to fix this problem. So thank you for that.
You're welcome.
I do have a clarification question, just so that I understand, and I'm going to be supportive of the bill. I just want to be sure that I understand. I think this might be for you, Mr. Steele. If someone records a grand jury proceeding and then distributes it or disseminates it, are they liable for two offenses because they recorded it and distributed it, or would this be prosecuted as one offense?
Off the top of my head, I would say they would be charged with two offenses. There may be a double jeopardy issue under the Blockburger. I see Representative Roberts is shaking his head no up there. So I'm just going off the top of my head. There could very well, no, I'm going to take it back. Under Blockburger analysis, there would be two separate acts. One would be the recording, and two would be the actual dissemination, requiring two different elements. So, yeah, there would be two offenses.
Thank you for the clarification, and thank you again for the bill.
Thank you.
Representative Roberts.
Just want to thank the bill sponsor, thank Mrs. Ballard for addressing this issue. But one of the points I wanted to really hone in on, and Mr. Steele, this might be a question for you, is there a risk of safety to witnesses in grand jury proceedings when their testimony is recorded and disseminated? And are there any cases that you can think of where that has been an issue that has resulted in people being afraid to testify?
Unfortunately, in my 23-year career now in prosecuting, we have lost 3 confidential informants. I can't say off the top, I can't tell you for sure it come from grand jury, that their identity was noted in grand jury, but that is always an issue. That is always a concern. A greater concern, not a greater concern, but another concern to look at is in metropolitans of Lexington, Frankfort, Louisville, Bowling Green, Northern Kentucky, grand jurors don't know the defendants majority of the time walking in or case being presented against. When you get to the smaller jurisdictions, Letcher County, where Representative Whitaker's at, you're hearing cases about your neighbor. And if you can't make an honest discussion, and if you can't deliberate in honesty about what's going on in your community because you're afraid somebody's recording it and playing it to your neighbors of what your vote is or what your comments were, that's, as Representative Elliott said, that's an obstruction of justice. You know, grand juries are supposed to be secretive, so those can be some honest discussions by our members in our community without retribution of people being brought in front of them. That's the reason only one person in the grand jury has to sign. The 4-person, they're signing as 9 out of 12 have to vote in favor of an indictment. So you don't know who, there could have been 3 people not indicted. You don't know that. Not supposed to know that. So that's why there's a secrecy issue, so for the protection of the grand jury members.
Thank you very much. Is any other member seeking recognition? If not, Mr. Clerk, please call the roll.
Representative Banta,
Yes.
Representative Ballman,
Yes.
Representative Blanton, Representative Burke,
Aye.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Flannery,
Yes.
Representative Griffey,
Yes.
Representative Kulkarni, Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Marzian, Representative Moser,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Roberts,
Yes.
Representative Stevenson, Representative Whitaker,
Yes.
Representative Williams, Representative Wilson,
Yes.
Chair Elliott.
Aye. So with 17 yes votes and no votes and no pass votes, House Bill 305 as amended by the committee substitute is passed and will be reported with favorable expression. The Crystal Rogers Act.
Thank you.
Thank you very much.
Thank you.
And if there's no further business to come before the committee.
Mr. Chairman, I'd like to
Yes.
record a yes vote on House Bill 249, please.
Thank you. It's recorded. Any other member? Representative Moser.
Mr. Chairman, I'd just like to record my presence.
Thank you.
It's recorded. So if no other business to come before Representative Burke.
Thank you, Mr. Chairman. I would also like to record my presence and a yes vote on House Bill 50.
It's recorded. So no other business is to come before the committee. Will stand adjourned.